Talked about how the United States Supreme Court has encouraged arbitration agreements, and it's come up in a number of cases, and the Federal Arbitration Act has become very important, and it's an opportunity for business owners to decide whether or not they want to have their disputes with employees, customers, vendors decided in court or in arbitration if it can't be resolved. Well, the National Labor Relations Board, which handles the administration of the National Labor Relations Act, has an interesting situation. President Obama appointed a person as a recess appointment, a Mr. Becker, and it's very controversial as to whether Congress was in fact in recess, and there's actually litigation pending over whether or not he was properly appointed. And the importance is his appointment was needed for the NLRB, the National Labor Relations Board, to have a quorum. But in the meantime, he's serving, and the NLRB just issued a decision. It's actually in January, and it's on appeal now, but it involves whether or not a D.R. Horton, the building company, I think based in, I think it's Florida, they required employees to sign as a condition of their employment a mutual arbitration agreement, which provided for two things. One, that there'd be binding arbitration of all disputes, and two, it prohibited class actions either in arbitration or in litigation. So the issue in the case, an employee brought a unfair labor practice charge claiming that this arbitration agreement was actually an unfair labor practice in violation of the National Labor Relations Act. So the context is the National Labor Relations Act protects concerted activities by employees. The ability of employees to come together, to communicate with each other, and to work to improve their wages, hours, working conditions. And so the issue was whether or not this class action waiver was an unfair labor charge under the National Labor Relations Act.